All right, everyone. My name is Jonathon Homa, and I am an associate attorney at the Sinus Dramus Law Firm. I've been practicing at our firm for many years, and one of the things that we specialize in is the no-fault law in Michigan, and generally represent and advocate for numerous people who have been injured in automobile accidents in Michigan. I would like to thank Therapy Solutions Rehab for co-hosting this event with us. It looks like we have a great turnout for tonight, and that's no surprise to me given the recent changes in the No Fault Act. So I know many of you are going through difficult times right now and have a lot of questions and concerns with regards to the changes in the no fault law. Our firm is here and we're committed to keep everybody educated about the changes in the law, how the law is being applied, and that's what we're going to talk about tonight. The purpose of tonight is for me to really give you the basics of the No Fault Act and all of the changes and what the law really means now for both providers and survivors who are in the system. And we do have other events that are going to continue our education, some that are coming up very quickly. In fact, this Wednesday, I want to let you know that we'll be having a no fault survival course, which is geared toward medical providers and helping them understand the issues of the no fault law from a provider perspective. And that's happening this Wednesday. And it's through CPAN, the Coalition for the Protection of Auto No Fault Law. And I'll give you the contact information and information at the end of this presentation. So you can follow up at the survival course if you want to, and also a town hall that's being hosted by CPAN next Thursday on July 29th at 4 p.m. That town hall is really meant to address the concern of survivors, let them speak, answer questions. And so I encourage everybody that's attending tonight to also attend the CPAN meeting this Wednesday and also Thursday, the 29th. And I'll give some more information on that before we end tonight. So tonight, I do have a PowerPoint presentation, so I'll go ahead and get that loaded up. And really what I'd like to do here is just, like I said, give you the basics of all the changes in the no fault. I'm going to start about where we started and with the reforms in 2019, really what those changes, what changes went into effect at those times, and then the changes in July of 2020. I'll spend some time with, but I'll spend the most time tonight on the recent changes that went into effect July of this year regarding the fee schedules and the attendant care limitations. So if you have questions for any of the content along the way, I encourage you to put them into the chat. I'll try to address questions as I go through the material, but I'm hoping that many of your questions might be answered with the material that I cover. But certainly I'll take some time at the end to go through all the questions and answer all of them to the best of my ability. So if you don't hear an answer to your question through my presentation, just know that I will be addressing the questions at the end. If you do have questions, feel free to post them in the chat along the way, and I'll get to them at the end of the performance or the presentation. So let me see if I can pull up my PowerPoint here. Okay, well, I hope everybody can see this. This slide, I like this depiction of the signs because we all have a lot of choices to make now. And with the new law, it seems like there's new choices. And so we're going to try to navigate what those choices are and try to work through some of the changes in the no fault system. Any questions or any further correspondence to us or our firm, you can see our contact information right there. And we're always here to answer questions and help advocate for the injured. So what problem are we really trying to solve here? Well, the No Fault Act, as many of us know, was written to help provide a better quality of life for those who are injured in auto accident victims. And we've had a very robust system, one of the most robust systems in the entire country since it was inception in the 70s. But really the basic idea here is that we're trying to provide medical care and benefits to those who are injured in auto accidents in Michigan to provide a better quality of life for everybody. From 1973 to June 11th, 2019, when the reforms actually went into effect, we had what I like to call a two-hand system. In that regard, we had no-fault benefits on one hand, and no-fault benefits would take care of an injured person's medical bills, their lost wages for up to 3 years, or replacement services around the home for 3 years, or in the event of a death, survivor's loss benefits. And that was on a completely separate hand than a liability case against the at-fault driver, for which you would seek pain and suffering damages or any excess economic care for lost wages beyond 3 years. And in this case, or in this scenario, one hand didn't really talk to the other hand. These were really two separate sets of claims, and they acted independently, one against your no-fault insurance company and the other against the at-fault driver. And the way the system was designed, those were very distinct, and there's very little overlap between those two sets of claims. In other words, another nice way to say it is the damages were completely separate. And for what you could get from the no-fault carrier in the no-fault hand, you would not be able to get from the liability driver in the liability hand. So we have the no-fault PIP hand, which is what I talked about. The allowable expense benefits, this was pre-2019. And this was an unlimited benefit. When we say allowable expense benefits, an easy way to think about it is your medical benefits. This provides all reasonably necessary products, services, accommodation for an injured person's care, recovery, or rehabilitation. It was very broad language. It was by large part a reasonable basis approach. As long as the treatment was reasonable and the charges were reasonable, you would be able to obtain those benefits. The next benefit was work loss benefits, which would compensate you for lost wages that you miss on account of your injuries. That would be paid at 85% of your salary for up to 3 years. And then we have replacement services, which were considered household chores type of services that you would be entitled to up to $20 a day. And survivor's loss benefits to provide benefits to those loved ones and family members we've left behind after a loss. Those benefits were up to 3 years. On the other hand, the tort liability hand, we would only claim the non-economic damages and the excess work loss, which would be work loss you would be typically entitled to under your no-fault insurance, but those benefits expire after 3 years. To the extent you are still incurring work loss, you would be able to claim those in your liability case against the at-fault driver. The non-economic damages, pain and suffering damages, quality of life damages, all interchangeable, but they're really just designed to compensate someone for the pain, suffering, hardships that they've had to endure on account of their injuries, which was only collectible from the at-fault driver. Who paid for each hand? Typically, not in every scenario, but typically the no-fault benefits consisting of your allowable expenses, your work loss, your replacement services, and your survivor's loss benefits would be paid by your own insurance company under your own no-fault policy. The tort liability hand, the non-economic damages, and the excess economic damages, those would all be coming from the at-fault driver. All right. Well, that was the system as it appeared until June of this year. And here you can see my graphic, kaboom, which essentially signals the explosion of the way the No Fault Act as it existed. So at that time, we started treading into three different phases of the No Fault Act. When it was originally enacted, there were three, what I like to say, main time periods or three phases. And the first one started in June of 2019. The second one, July of 2020. And then the third phase just started July 2nd of this year. And so each phase came out about 1 year apart, and they all changed the system in various ways. And I want to just go back to the beginning of phase one, where we were at in 2019. And I'll briefly go over the changes in the first phase and the second phase, and then I'll spend more time on phase three. But the changes that came effective in June 11th, 2019, the first had to do with out-of-state residents. Out-of-state residents, they're the ones that essentially got dropped out of the system right away. Out-of-state residents simply are not entitled to no-fault benefits, period, unless they both registered and insured their vehicle in Michigan. That is a very small number of out-of-state individuals that drive in Michigan. And so essentially the way the system looked at it is that if you actually had a car registered here and actually had a no-fault Michigan no-fault insurance policy on that car, that would be the only way you'd be entitled to no fault if you're an out-of-state resident. And actually, one more thing I'll say about the out-of-state residents. They are not left completely without recourse. An out-of-state resident that is injured in an automobile accident in Michigan will be able to claim medical expenses and damages for medical expenses from the at-fault driver in the liability case. So this is one of the first instances that you're going to see the hands coming together. But essentially, the out-of-state resident would be able to pursue a liability claim, but they would have to show that the driver of the other vehicle was at fault, and they would also have to show that they sustained a threshold injury, which is a concept that we've had in Michigan for liability cases even before the changes to the no-fault law. The threshold essentially says that before you can sue somebody for liability damages, you must establish a threshold injury, which is designed as death, serious permanent disfigurement, or a serious impairment of an important body function, which generally means it affects your ability to live your normal life. The long and short of it is that you have to have a serious injury before you can pursue a case against an at-fault driver, even if you're an out-of-state resident claiming medical benefits as well under the new law. Now, the second class of individuals, or the second major change that came in 2019, was the priority provisions. And the way the priority provisions changed, I'll walk through it and how it changed a little bit. Now, if you're injured in Michigan, we all still look generally to our own no-fault insurance policy. And so that part of the law has not changed. But what did change, and I'll say this, we look to our own no-fault policy unless there's one of three exceptions. The three exceptions are if you're in a vehicle for hire, if you're in an employee-owned vehicle, or if you are on a motorcycle. In those situations, the priority rules would dictate that you essentially would claim from one of the other drivers or the driver of the vehicle that hit you. And I'm not going to go into too much detail with that right now, but just know that the major change is if you're not occupant or one of those sections don't apply, or if you're the occupant of a vehicle that doesn't have your own no-fault policy or reside with a resident relative that has a no-fault policy, you would go right to the assigned claims plan. And the assigned claims plan would be set at a $250,000 cap. So before, if you were an occupant in a vehicle in Michigan and you were injured in a crash, and you did not have no fault coverage, you would look to the owner of the driver for PIP coverage. But now you go to the ACP and you are limited at $250,000. So not only does it change the priority, but it really changes the amount of benefits you're entitled to receive if you're an occupant that does not have your own no-fault policy or reside with a relative that has a no-fault policy. As I mentioned, anybody in the assigned claims plan in this scenario is subject to a $250,000 limit. And one way to think about this is it's a pay-to-play regimen. Generally, those people that used to draw off of other person's PIP policies and have full coverage, full medical for life, no longer get those benefits. It's now a pay-to-play system. Those individuals go to the ACP and are subject to the $250,000 cap, whereas those individuals who continue to have their own policy would be able to take benefits from their own policy at the level of coverage they purchased. Some other changes, minor ones, we have provider statutory cause of action. This was something that was recognized long before in the system, but the Supreme Court Covenant case really shook the ground on providers' rights to bring private causes of action. Well, the new law essentially went back to the traditional ways and really expressly stated providers do have a statutory cause of action so long as they can show the benefits are overdue. And that essentially just means that the charges were submitted and the insurance company didn't pay. But so long as the benefits are overdue, the provider now can bring a cause of action on their own behalf without concern of the covenant decision of the Supreme Court. Another change is the statute of limitations tolling. Before, there was strict application of the statute of limitations and the 1 year back rule in the No Fault Act. However, those rules have essentially changed and they allow for tolling from the date a specific claim or proof of the claim is submitted to an insurer until the date they deny that claim. However long that time period is, you get to add it to your statutory periods and essentially toll the statute for that same amount of time and not have to worry about the notice provisions or the 1 year back rule within that window of time. So it made it a little bit easier and it provided a little bit more room to bring claims, especially those that ultimately get disputed by the insurance company. Another change that's important to know has to do with the independent medical examinations. I don't even think they're independent medical examinations. I believe they're more aptly characterized as defense medical examinations. These are the scenario where the doctor is picked by the insurance company to review your medical condition, and they use it quite often as a basis to deny coverage. These doctors do not have a physician-patient relationship with you or the claimants or the persons they're examining, yet they are able to write a report with their medical opinion that can be used by the insurance company in relation to the claim. With regard to the changes that were made, the No Fault Act actually added some protections here. Specifically, if the care at issue in the no fault case is being provided by a specialist, the no fault company is now required to get an independent medical examination with a doctor of the same specialty as the care provider. In other words, you could not have a primary care physician, IME, contest the opinion of an orthopedic surgeon because they are different specialties. It has to be apples to apples and oranges to oranges now in some regard. Another limitation that goes with that is that if your care provider is board certified, then their doctor also has to be board certified as well. The language in this provision also refers to these IME professionals as physicians, and the word physician appears over and over in the statute. Therefore, I believe there's a good argument that the IME doctor actually has to be a physician, an MD or a DO. It could not be a PhD providing a neuropsych or a chiropractor. And this also, I think, really becomes apparent when you look at some of the other provisions that say these IME doctors have to spend more than half of their time dedicated to actually treating patients or teaching essentially residents in a medical school. And why that's important is because these insurance companies cannot use doctors that have decided not to treat patients anymore that only do IMEs for insurance companies. It's a way to remove that bias from the system. And so now the doctors who are being hired by insurance companies are required to show that they're actually in the practice of medicine majority of the time. So those are some extra protections when it comes to the IME medical examinations. Okay, now we're getting into July 1st of 2020. And this was when some of the major provisions started coming into effect. Specifically, we all got introduced to Pip Options, okay? The Pip Options were designed to allow individuals to buy different levels of care. And depending on what level of care, you were guaranteed a specific reduction in your premiums. And we'll go over that a little bit in those specific reductions. But there's a couple things that I'd just like to say about those up front. One, diffs and the implementation through diffs of these different levels of coverage required insurance companies to produce forms and to go through some procedural work before they were actually able to start offering these options. So we didn't see them roll out right on July 1st, 2020, but certainly as we are here now, we see various levels of coverage. And I'm going to kind of go over each and every one and exactly what they really mean so people can understand now what types of coverages and how your choices with regarding your level of PIP coverage can ultimately impact what benefits you're able to obtain. And before actually I go into this, I'll just see if we have any questions. Alicia, if you want to stop me, you're more than welcome to. I actually can't see them here on my window. So the first benefit that we're going to have is the lifetime option uncapped. Now, we recommend this benefit for everybody. This is also going to be the default rule if you're not picking a policy or asked to pick a policy from your insurance agent. The other types are qualified health insurance opt-outs, which means that if you have coverage in your house that protects and provides for auto accident injuries, then you can actually opt out of no-fault benefits in certain scenarios. There is a $500,000 option level for PIP benefits, a $250,000 option for PIP benefits, and we'll talk about the attendant care rider, which actually supplements or can provide additional coverage for allowable expenses under these different tiers of coverage. And finally, we'll talk about the managed care option and what that means for claimants and insurers. Also, there's a $50,000 opt-out, what we call the Medicaid opt-out if you qualify for Medicaid. And we'll talk about each one of these in a little bit more detail as I go forward. Okay. Okay. So one thing to say up front about these benefits are when we talk about these caps for PIP, these are caps on the allowable expense portion of the policy. These are not caps on the wage loss or replacement services or survivor's loss or other benefits that you might be able to obtain. Also, the per individual and per occurrence, you'll see that the cap applies to each individual claiming under the policy. And so it could be different, or that it might be different if there's more than one individual injured out of one occurrence. But essentially, think about these caps as applying to each individual that's claiming benefits within that policy. Okay. How to choose? Well, yeah, go ahead.
Sorry, there's a couple of questions in the chat.
Okay, let me have to move out here. Okay. The slides can be made available. So I see that. So anybody, I can work with Alicia and we can get them posted. And also we can make sure that additional information is available through our website. Alicia says she's going to follow up. I will get to the implications of children at college or not living at home. So I will cover that in my presentation coming up. And so let me get back to my presentation because we are going to be coming up on this issue. In fact, I can cover the the college or not living at home issue because that issue hasn't really changed from the old system. And what I mean is that essentially if you are considered to be domiciled with your parents while at college, even if you're away from home, the real inquiry and what courts have looked at is whether or not you're domiciled with your parents. In other words, whether you have an intent to return to your parents' house permanently. There's been some cases, and the cases have cited several factors, things like kids getting mail still while they're at college, still having a bedroom and keeping clothes at their parents' house, having their driver's license still say their parents' house address. Multiple factors to show that essentially their intent was always to return to their parents' house, and therefore they're essentially still a resident relative of their parents. Now, my concern, though, is that this could be danger. The law talks about the right to benefits for a resident relative. And one of the things that I worry about is that insurers will make an argument that when a child moves away to college, that they're no longer a resident relative, and therefore they're no longer able to claim benefits under their parents' policy as a resident relative of their house. And now there's lots of factors that how to protect them, and I'm not going to get into all the different factional scenarios, but generally, if the child is driving the parent's car while they're at college and that car was insured, that would be a different scenario for which would be easier to draw under their parents' benefits, for as if they own their own car and they were at college with their own vehicle. There is arguments to be made by the insurance company that the vehicle wouldn't be garaged at the parent's house or things like that. I really suggest communication with agents for this type of coverage, and just know that it's dangerous to assume that your a child at college or somebody not living at home would be considered a resident relative and able to draw PIP under the parent's policy under that grounds alone. They might need to be a named insured on a separate policy or be listed as a named driver with a car garaged out of location of the home. But these are discussions to have with your insurance agent. But I would certainly say that I would caution, it would be, there's danger everywhere to assume that the child is a resident relative for which benefits flow straight from the parent's policy without anything else in the policy. So, yep, and I'll tell you, these are good questions for the town hall too, coming up next Thursday. It'll be a much more of an open format, and so I encourage anybody with questions, like I said, to follow up both the town hall and the course coming up on Wednesday. Okay. When it comes to choosing your levels of coverage on PIP, it's important to read the fine print. It's important to ask questions from your agent and really try to understand the coverages. Different companies represent these different tiers of coverage in different ways, but I'm going to go through them all, and this is the law and would apply universally to every insurance company, regardless of what forms they produce. So, the lifetime option, okay, this is what we call the unlimited, okay, lifetime option. This is what our firm recommends. It's available to anybody. Any person can buy this. It applies to the named insured on the policy, their spouse, or any domiciled resident relative. This is the default rule. So if you haven't specifically called your agent and said, hey, I want to lower my coverage, if everybody just kind of let it lapse, you would be, this is the default coverage, so you would have unlimited. You would be charged the appropriate premium. The new no-fault law guarantees a 10% reduction in PIP benefits on the PIP benefits line item on your charges on your policy. The next option they're going to offer is the $500,000 option. Very similar to the uncoordinated in the sense that it's available to anybody and applies equally to your spouse or resident relatives. And this would offer a 20% reduction in your premium. The $250,000 option, same as the other two, applies to any person. It would cover your spouse and your resident relatives. And coordination. You can coordinate these types of policies with your health insurance, as many people did before, where you can essentially bump your own health insurance, or what we would call a qualified health coverage. We'll refer to that later, but essentially you can bump your health insurance to the primary position with one of these three types of policies, the unlimited, the 500, or the 250, just as you would have before. Okay, here's a scary proposition. When someone else's choice becomes your patient's reality, or your reality if you're in the system. Motorcyclists, okay, the way we now draw coverage in the priority rules, motorcyclists essentially draw off the striking vehicle, even if they have their own policy, which is scary. If you bought yourself an unlimited PIP policy and you're riding your motorcycle and you're hit by somebody else, the way that the law is currently written and working, you would be forced to draw benefits off the driver or the car involved, and you would be subject to their cap, whatever it is. Similar with employer furnished vehicles. Okay. The same type of priority rules would apply, which would essentially make you draw right from their policy, and you would be subject to whatever coverage they decided to purchase. And you would not get the benefit of your own unlimited PIP policy if you did have one. Okay, the next type of coverage, one tier down, we've talked about the unlimited, the 500 and 250, who can, anybody can purchase that. There's no other qualifiers, but now we're going to get into an area of coverage where you actually have to show that you have existing qualified health insurance coverage. Okay. And there is a 250,000 opt out for this, but essentially it's an opt out is what it means. You can select it if everybody, if you, your spouse, and all your resident relatives, anybody that would normally draw under your own PIP policy, has other coverage that extends to auto accidents. Okay. And it also have an exclusion for allowable expense benefits. And you'll see this option right here. It does call it a 250,000 per person per accident, but in reality, this is just an opt out. Okay. And like I said, what they're going to look for here and what they mean by qualified health insurance is that health insurance doesn't have any exclusions for auto. They will agree and have agreed to pay for auto related injuries and expenses. And also that the annual deductible is not $6,000 or less. I'm sorry, the annual deductible is $6,000 or less. If the deductible is more than that, they won't consider that a qualified health coverage. It's just not enough to show that you would be covered if you were injured in an auto accident. Another way would be, here's this, another way would be you're covered by Medicare Parts A and Part B. If you are covered by Medicare Parts A and Part B, that would be considered qualified health coverage. And you would, on a showing that you did have this coverage to your agent or carrier, you would be able to purchase this qualified health insurance opt out. Okay. And essentially, the reality of this, if you are injured in an accident, there's no PIP. It means what it says. You opt out. Okay. And the way the statute is written, though, I won't get into too much detail here, but if you find yourself in one of the non-occupant scenarios, you are a pedestrian, let's say, that is hit by a motor vehicle, and you have this opt-out provision. The way the law is written, you would be able to go to the ACP still, sign claims plan with the $250,000 cap that comes with it. So you, in most situations where you'd be driving or the occupant of a vehicle under this coverage, there'd be no PIP. However, if you were a non-occupant, you would be able to entitled to PIP under the ACP subject to the 250 cap. Okay, so here's a question. What if you sign up for this opt-out provision? You have Medicare A and B, let's say, and you think you're happy with that coverage if you're injured in an accident, so you opt out. And then you either lose Medicare, there's a mistake in, whatever there is, and your health coverage lapses for some reason. And this could be if you have, another qualified health, even a private health insurance company. If that lapses, there's some language in the new fault law that talks about what the requirements are of the claimant. Essentially, the claimant has 30 days from the lapse to buy an uncoordinated policy from their carrier. And there it is, 30 days, or yeah, well, we know what happens if you don't. You're going to have no coverage, okay? So it's incumbent for people to watch their health insurance and just recognize this issue for the scenario when you do elect to have this option and there's a problem with lapsing of your health insurance company. Some people wouldn't even think about it for 30 days, but by that time it would be too late. So it's important to understand anybody who's electing this opt-out to keep an eye on their health insurance and make sure that it's maintained. Another thing, if the person is injured in that 30-day window while their health insurance is lapsed, they would be able to go to the ACP for their no-fault benefits. They would be subject to a $2 million cap. It's a unique value that is certainly elevated above the 250,000 cap, and it only applies in this narrow context when you've opted out with the qualified health insurance, your health insurance lapses, and you're in an accident within that 30 days. So very narrow circumstances when this issue will arise, but if that does happen, as long as you do go out and get your uncoordinated policy or you have time to do it, you will have $2 million from the ACP and PIP benefits. Okay, the next election you can make is a $50,000 opt-out with Medicaid. And you can do this if you're covered under Medicaid, you qualify for Medicaid, and every person or your spouse and every resident relative has also qualified health coverage, other PIP coverage, or Medicaid. So in other words, what they're trying to say is that as long as you have Medicaid and everybody else would be covered by a form of insurance or benefits in your family or your household, if there is an accident, then you can elect to have this option. You would have $50,000 in PIP until your PIP benefits are exhausted, and you would turn to your next layer of coverage. Now, I've got 2 pages up here and they're kind of similar, so I'll skip through this one, but I'm going to show you a list of what's covered under no fault and what's covered under traditional Medicare. This relates a lot to the Medicare opt-outs, but it's similar for Medicaid too. And the purpose of this slide is just to show how many benefits and different types of services are covered under the no fault scheme, but are either eliminated or drastically reduced under Medicare. And so it's these areas of service where you're going to see the difference, or where the benefits are really going to change by electing one of these different types of provisions. But I have another one coming up here in just a few slides, and so we'll take a little bit longer look at that one. But I want to talk about the Medicare opt-out. It's very similar. This is a complete opt-out, okay? And it's very similar. The person's covered under Parts A and Part B of Medicare, and the spouse, every other resident relative has qualified health coverage, other no-fault PIP coverage, essentially another way to cover them if they're injured in an auto accident, and they wouldn't have to rely on your policy. If this is the case, complete Medicare opt-out, there's just no PIP benefits at all. And so you would be in the Medicare system. And as you can see, this is why we recommend uncoordinated benefits, is because people who are injured often need multiple different types of services and cares, a lot of specialty care, especially those who have either brain injuries, spinal injuries, or really need rehabilitative care, long-term care, not covered by Medicare, residential treatment programs, not covered by Medicare, case management, not covered by Medicare, attendant care, very limited, guardianship, conservators, transportation services, replacement services. None of these benefits are covered by Medicare. You would be able to get all of these benefits if you elected to have no fault. Occupational therapy, very limited. Physical therapy, speech, language, other outpatient therapies, very limited under Medicare. And massage care therapy, not covered at all. So you can see that you get a lot more for the no fault. And I always thought that no fault, dollar for dollar, based on how many benefits you can receive. I mean, it is really everything that was reasonable prior to these amendments. I really thought it was some of the best coverage dollar for dollar, and it really still is. And it's because you have access to all of these types of services, which you otherwise would have to pay either out of pocket for, co-pays for, through another system. The managed care option is, this is essentially something, well, this is dangerous. I'll just say this right away. This allows insurance companies essentially to set up a system where they can, it reminds me of an HMO type of situation where they can set up a network of providers and be very involved with the decisions made regarding your care. One of the words that I see, it's right in the statute, it says the insurance company is entitled to the monitoring and adjudication of an injured person's care. Putting these types of benefits and these care options and how they're going to be using this statute has really not come to fruition yet. So there are some unknowns, but it's easy to see that the insurance companies are going to want to drive the bus with regards to all things care. And we all know that insurance companies look out for themselves and they have their bottom line. And I think it's just very dangerous to trust an insurance company with this strong language, allowing them to manage so much or have so much dictation over what type of care you're able to receive, that I just simply would not recommend this option at this time. Yep, it's a trap, right? That's what they want you to think, is that it's going to be cheaper and similar care, that it won't be much benefits lost or nothing to worry about. I believe this is a trap for them to save money and really put their hand in the cookie jar and start dictating how a person receives care much more than they should. So all representations say stay away from the managed care. Another thing that went into effect, while it doesn't relate to PIP, we're talking about the liability hand, and this is our liability coverage in case that we are involved in the accident, that we are at fault, and what the insurance companies require us to keep for our own protection. Default limit is now $250,000 per person, $500,000 per occurrence. Everybody might remember 20-40 days. 20,000, 40,000. Well, that's no longer the law. The law says 250, 500,000. However, if you submit written request via written reform, you can opt out of this level of coverage, which would take you down to 50,000 per person, $100,000 an accident. This would obviously save you presumably some measure in your premiums, but I don't think it would be worth the savings. Especially because we have to think about the new world that we live in, which is the fact that we could tomorrow or today hit somebody, be at fault for an accident. Let's say it's an out-of-state individual. They have no coverage for their medical expenses. Well, before in Michigan, medical expenses were all taken care of by our no-fault system, regardless of who you were, for every accident in Michigan. So most of us were protected from getting sued for an exorbitant amount of medical bills, $2 million in medical care, because we were at fault for an accident. It was typically paid for by the no-fault insurance. It was on one hand, liability case was on the other, and we would never actually have to be liable for those expenses. Well, that is just simply not the case anymore. Now, if you hit an opt-outer, if you hit an out-of-stater, you could be responsible for their medical expenses from day one and dollar one. And that could get, that's a huge exposure for all of us in terms of our liability. And so we recommend sticking with the 250, 500,000 because we all simply have more exposure now. And this is incredibly true when we talk about how the new PIP options will roll out and how we'll be liable for medical expenses and many other types of cases and crashes going forward. And so we recommend get good liability insurance, cover your assets, and we'll talk more about underinsured, uninsured motorist coverage and umbrella policies. I really think it's prudent for everybody to really think about these types of damages and making sure you're covered. With regards to liability, it would be have enough liability to cover your assets and think about an umbrella that would tie to this, because it's usually pretty cheap and will help you in the event that you do unfortunately hit somebody and cause significant medical expenses to be incurred. Another interesting, and this is kind of what I'm getting at here, is that these excess PIP benefits, what happens if you have 250,000, you chose that option, and you're catastrophically injured and your medical expenses are $1 million or $500,000. You're far over the amount of coverage that you purchased for yourself. Well, the legislature said that now we can go ahead and sue the other driver for those benefits in excess. Okay. This would be $1 for the opt-outers at 50,000 Medicaid, or, depending on the tier that you bought, the 250, 500, it would flow from there. But essentially, if you have additional expenses that exceed your PIP benefits, those are now, you can sue the other driver in tort, okay? It's part and parcel of why I'm recommending the extended liability coverage, and it's really merged the tort law and the no-fault claims together, okay? So when you look at the big picture, we have the two hands wrapped together now, and it's because the PIP benefits, the deficiencies on the PIP side are now going to move to the tort side. And the implications for that are multifactorial. They're very complex. I'm not going to get into all of the situations that arise, but one obvious one is that future medical care is largely uncertain. We always want to hope for the best and plan for the worst. But with a tort liability case, statute of limitations, generally 3 years, that's your opportunity to sue for all of your future medical expenses too. And it's going to be incumbent on attorneys to really work up what the reality of future medical expenses are for these individuals, what that really means. And we're going to have to be able to bring the needs, the future needs for medical expenses, and put that to $1 and get that claim in the tort side within the first 3 years of the accident. And so when the hands are together, this is really a whole new world for attorneys, for claimants, for insurers, having to look at the PIP benefits and the excess PIP benefits now going over into the tort and into the liability case, so there can be additional recourse. And this is especially true for catastrophic claims, for serious injury claims. People who are expected to be in the system need medical care for many years to come, if not the remainder of their lives, people with permanent injuries. And so it's incredibly important to understand the rights and where the benefits will ultimately come from if you're catastrophically injured and unfortunately have one of these lesser tier no-fault policies. Okay, so that gets through essentially the three or the first two phases, but I'm going to take a moment to go into the chat here and see if I can cover any questions. Okay. All right. So the new lifetime coverage, I've got a question here. How does the lifetime coverage compare now in comparison to the auto no fault before Public Act 21? Well, the lifetime coverage, essentially, it means the same thing. The real reality is that you'll have a lifetime benefits. Time duration, there's certainly no change. We do think that the fee schedules will be applied or intended to be applied by the insurance carriers, regardless of whether you're uncoordinated or you pick a tiered option. So I'll get into those in phase 3 a little bit, but essentially there's not much difference other than the fee schedules if you just continue with your uncoordinated coverage. Can you give us an itemized list of what the new PIP allowable expenses are with the new law PA 21? Well, the definitions of allowable expenses has not really changed. These are still reasonably necessary product, services, accommodations. However, the fee schedules that apply and how those fee schedules apply, essentially what different types of services will be reimbursed and at what rates, has changed dramatically. And we'll cover that here in my next section. I've discussed the coordinated, uncoordinated option with my insurance company several times, and they claim to not have that option. Is this typical? Well, I guess in the old no-fault world, it would be unusual for an insurance company not to offer coordinated benefits. And my understanding is that almost all carriers would allow this type of coordination in some context under the law, and they would offer a reduced rate for premiums. What insurance companies do, believe they have the option, so it's not mandatory, but they may option to provide coordinated coverage. I wouldn't be surprised if they aren't coordinating with every tier of coverage at this point. And so that might be something that as they continue to see the system work and in months to come, they will offer different products in terms of coordination. But it would seem to me that the insurance company certainly has a benefit to coordinating their coverage. And so I would expect carriers essentially to continue to provide that to the extent they can. Do they inform that clients A and B do not care for catastrophic injuries? No. There's very little education on what these benefits mean, especially from the carriers themselves. Most of the information is coming from agents at the ground level, which is both independent and captive agents. And so depending on the agent, and if you ask, you can certainly get some answers to these questions. But the chart that I saw and all the services that wouldn't be provided under Medicare's system are not upfront and readily explained to individuals contemplating these different options. So it's important that people understand before it's too late so they can get the policy that best suits themselves. Those now living out of the state, how does this affect? Well, depends on, like I said, the out of state. If you're just an out of state individual, you reside out of state, there's no PIP benefits at all. And so you're left with just a couple options. That would be either suing a liability driver for your medical expenses or looking to alternate forms of insurance. The only way you can protect yourself if you're out of state is if you register your vehicle in Michigan and you have that vehicle insured under a Michigan no-fault policy, even though you reside out of state. Share the page, auto no-fault, first Medicare. These slides will go out, so everybody will have access to that. I see a service talking, we're really getting into the fee schedules when it comes to these Medicare rates. I'm going to cover those in detail here as we go forward, assuming we have time at 6:30. So we're making good time. And so I'll certainly spend some time here talking about the different types of providers and how the new rates under the fee schedule apply to each one of those providers. What is happening with the people who have been injured for the past 20 years? Aren't they grandfathered in? Well, it's certainly our firm's position that they are, but I can tell you right now that the insurance companies are really fighting this issue hard. It's clear that their intent is to imply the new changes retroactively to the persons that are already and have been involved in the system. And so we'll talk a little bit about that issue. It raises some constitutional issues, and we'll talk about the case, which some updates on the case, which our firm is litigating to try and repeal the No Fault Act, or at least the provisions that we believe are unconstitutional. Legal services limited, guardian and conservator. Well, that's a good question. The short answer is the insurance companies will be trying to limit those benefits subject to the fee caps. Essentially, it's all allowable expenses that are getting limited. This is what guardian and conservator fees typically arose under. They were required for the person's care. And so we believe that the carriers will intend to apply the fee schedule to those fees as well. It's a little bit too early to tell exactly how that's going to play out. And like I said, I'll touch on that in the next section. That's a guardian, similar question. I see a question regarding the number of visits, like for example, physical therapy. Are visits going to be counted, or will they go back and look at how many visits have been provided and stop? It's really not a numbers of visits analysis. It's going to be a dollar per service analysis. So they'll say that certain services can only be billed at certain rates, or that and that's really where you're going to see it. I don't think that they're going to pay the same price and then try to limit the number of visits to come under the monetary cap or the fee schedule. It's going to be just simply applied across the board to every type of service up until you reach your cap, if you have one. I do recommend uncoordinated coverage, absolutely, no question there. For those who are injured and need those additional services that Medicare, Medicaid don't provide, I do think it's worth it. So that's I can say that's our firm's position, not just mine, but all of my colleagues. If I'm a passenger in another vehicle, am I covered under their choices or my choices on my own vehicle? If you have your own no fault, you would be covered under your own choices. If you're an occupant, unless you're in one of those three unique scenarios, whether you're on a motorcycle, in a vehicle for hire, or an employee-owned vehicle, and those all have a separate analysis. But essentially, if you're in a friend's vehicle, family member's vehicle, an occupant, you would drive and be entitled to all the benefits under your own policy. Yep, getting to number 3 here. This is really getting into fee schedules. I see a lot of questions going into fee schedules, so I'm just going to go ahead and jump right into the fee schedules. So here we are, new world. This is the two things that I like to say in phase 3. This is the most talked about, and this is really what it's about. It's about the medical fee schedules that are going to apply, or which the insurance companies are going to attempt to apply across the board, and the changes to the attendant care rights. Well, we can go back to the old rule, and excuse me. Here we go. This is the reasonable charge, the reasonable basis, the reasonable amount. It was generally based on your demographic, what similar services were provided for in your area. It was always an issue what a reasonable fee would be for typical different services, but that was the standard. It was reasonable basis. Okay, it wasn't tied to any other type of fee structure. It was essentially multifactorial, but it was reasonable charges. And the best way to think about it is within the demographic or area that you're living in for similar services. There's another provision that said the charge must not exceed the amount a person customarily charges for light treatment or training in cases that do not involve insurance. So if you walked in, had no insurance, and wanted to pay cash, they could not charge for more than whatever they would charge that individual under the old rule. Now we have the new rule, and the new rule is going to apply fee schedules, and depending on what type of provider you are, a different type of fee schedule will apply. And so I'm going to go through what we call the special provider types, and then assume that if you do not meet one of the special provider types, that you will be subject to just the general default rule. So I'll go through the provider types just so everybody understands the different types of providers and what they really mean. Tier 1 Medicaid provider means on July 1st of the year which the person renders treatment or training, the person has 20% or more, but less than 20% indigent volume determined pursuant to the methodology used by DHHS. In short, they have between 20 and 30% Medicaid indigent individuals, and therefore they would classify as one of these Tier 1 Medicaid providers. If you don't have 20% or you have more than 30%, you are not in this category. If you have more than 30%, you would be a tier 2 Medicaid provider. Any physician, hospital, clinic, or other person that provides 30% or more of its total treatment or training as described under subsection 4A, which is the last subsection I showed you. Essentially means that if you have more than 30% indigent individuals, then you are classified as a tier 2 medical provider or Medicaid provider, and that fee schedule will apply to you. The other type of provider that's carved out is a freestanding rehabilitation facility. Boy, there's a lot of requirements for these freestanding rehab facilities. The hospital staff has to be specialized in demonstrated rehabilitation medicine expertise. You'll see a lot of these are very general too, but they are going to require all of these. The hospital participates in rehab, research, clinical education, assists patients to achieve excellent rehab outcomes, coordinates necessary post-discharge services, accredited by one or more third-party independent organizations focused on quality, serves the rehabilitation needs of catastrophically injured patients in the state, and was in existence May 1st, 2019. Now, all of these criteria, when you read them right from the statute, it seems like they apply to almost every single rehabilitation facility. But regardless, that this is how it's defined. And you'll see a whole different set of fee schedules for a provider who's classified as a freestanding rehab facility. The two other types that are listed in the statute: level 1 and 2 hospital trauma centers, defined as a hospital that is verified as a level 1 or 2 trauma center by the American College of Surgeons Committee on Trauma. So you're either identified by them or you're not, and that will dictate whether you adopt the this fee schedule for hospital trauma centers or you don't. In the last category, non-accredited neurological rehab clinic. Notice here that it doesn't say a hospital, it doesn't say a clinic, it says a person that provides post-acute brain and spinal rehabilitative care that is not accredited by the Commission on Accreditation of Rehab Facilities or a similar organization recognized by the director for purposes of accreditation. What does that really mean? It means exactly what it says, non-accredited neurological rehab. But there's a very broad definition of who would fit into this category, namely any person that provides post-acute brain and spinal rehab care that's not accredited. I mean, that's a really broad definition. It could almost apply to anyone. There's been very little litigation or movement on this provision, how it will really apply, but certainly seems to be a basis in what the insurance companies may use to limit apply these fee schedules to everybody across the board. So if you're not in one of those lists, what we call the general providers, medical providers, you're just going to be subject to the default rule. The default rule, and these are all very similar. I'll say that the way these fee schedules are set up, they do two things. One, they say if there's a Medicare charge for it, this is the level of Medicare charge. And then they say if there's not a Medicare level or charge for this, then we're going to pay at a reduced rate. So it's a two-step analysis for each class of provider. The first one, looking to Medicare to see if there is a payment under their fee schedule for that service. And then if there's not, then you look to just the catch-all rule, which reduces the charge. So this is the new default rule for, and each section goes by year. So you'll see that under the default rule, those who don't fit into a special type of provider, for July 2nd, 2022, or until July 2nd, 2022, I should say, they're going to get 200% if that service is payable by Medicare under their schedule. The next year, it goes down to 195%. And the year after that, 190%. And the statute's silent as of what happens after well, no more changes identified in the statute. So presumably it would stay at the 190% in perpetuity until it is changed or readdressed by the legislature. Now, here's the default drop down that I talked about. If Medicare does not provide an amount payable for a treatment or rehab occupational training, the physician, hospital, clinic, or other person that renders the treatment or training is not eligible for payment or reimbursement under this chapter of more than the following. And here's the general caps. The applicable following percentage of the amount payable for the treatment or training under the person's charge description master in effect January 21st, 2019. Essentially, it's saying if there is a charge description master that the provider had, they're going to use that as a basis to determine the reduction. But if you didn't have that one in place, they're just going to use the amount that you billed for the treatment on January 1st of 2019. But they're just across the board reductions. So here we go. From now until July 2nd, 2022, 55%. So that's a 45% reduction. Here you go. And you'll see it step down to 54% the following year and 52.5% for the year after that. It tiers down and then it's silent after that date too. Presume that all these fee schedules just run after that last date. Now that was the general rule. Those are for general providers, but now we'll look at the ones for some of the classes. And remember, these all follow the same format, so I'm going to go a little bit faster here. But if you're a tier 1 Medicaid provider, and there is a charge from Medicare, then it would be 230%. Okay, so you can already see that there's going to be a significant more payable for these types for these individuals because they have a larger percentage of their claimants in the Medicare system. The following year, 225, in the following year, 220. Just like everything else, they step down every year. So this one starts 230, then it's 225, 220. This is for the tier 1 Medicaid providers that have between 20 and 30% indigent claimants. And yep, this keeps going, but essentially we'll get to the step downs here, which are the standard drop downs under the tier 1. They also have a higher rate of payment, but you'll see this is either from the charge master, and if there's no charge master, then it's from whatever they were charging for that same service back in 2019. But 70% is the reduction across the board. Then it drops to 68% in 2022, next year. And then finally it goes down to 66.5% the next year. Tier 2 Medicaid providers, remember they have more than 30% indigent. In this situation, 250% under Medicare, and they don't have separate tiers. So that's really the level, 250%, and that's it. Now, if there is no Medicare and they have to step it down, it just goes to 78%. Okay, so they don't do a 3-year drop down change. It's simply 78% of the charge master or whatever they charged January 1st, 2019. The fee schedule for freestanding rehabilitative facilities under the definition that I mentioned earlier is similar. We'll get to the first, if there are Medicare charges for that treatment or service, is 230, 225, and 220. And similarly, just as it was before under the other schedule, 70%, 68%, and 66.5%. Level 1 and 2 trauma centers. These are just what's been defined as a trauma center, but they have the same type of scheme with a little bit different numbers. So for treatment rendered after July 1st, if there's a Medicare payment, it's going to be $240, then $235, and then $230. You'll see that they get a little bit more, being a trauma center. Similarly, if there's no charge or if there's no description through Medicare of that item or service, then you look to the default drop-down rule, which this year, 75% is what they're entitled to. So 25% reduction, 73%, and then 71% of what they were getting paid essentially before. Non-accredited neuro rehab clinic. Just going to read this right from statute. Neurological rehabilitation clinic is not entitled to payment or reimbursement for a treatment, training, product, service, or accommodation unless the neurological rehab clinic is accredited by the Commission on Accreditation of Rehabilitation Facilities, or a similar organization recognized by the director for purposes of accreditation under this subsection. In other words, if you're not accredited, then you don't get paid. But it does have kind of an exception to that rule. It says if you are in the process of becoming accredited as required under the subsection on July 1st of this year, unless 3 years have passed since the beginning of that process and you're still not accredited, then you could still get payment. That you wouldn't be excluded as long as you are involved in the process of getting accredited at that time. All right, so that really does it for the fee schedules. You can see that depending on the type of provider, how many Medicaid or indigent individuals you provide service to will ultimately dictate what fee schedule will apply to you. And if not, you would go into the default rule. I think we can all agree that the reductions are horrible. That they're gonna not allow. They're not enough. They're simply not enough, and they're not enough to cover cost of care. In some cases, they're not enough to provide quality care, and certainly they're not enough to even keep the lights on in a lot of providers' businesses. And so we're going to talk about the reality of that a little bit more after I go through the limitations on attendant care, because I know these limitations just went into effect too. And so we've been getting a lot of questions on that. And I just want to make sure everybody understands what's going on with the attendant care compared to before and how is it different now. So attendant care does come from allowable expenses. It's a medical type of benefit. This is separate and distinct from, the replacement services, people who do chores and, cleaning around the house, typical stuff that don't necessarily relate to our care, recovery, or rehabilitation. So those services, which are the attendant care services, it used to be a reasonable basis, but they consist of all reasonably necessary products, services, and accommodations for an injured person's care, recovery, and rehabilitation. You see that extremely broad language from 3107. And then we get to the new rule. For attendant care rendered in a person's home by a relative, someone living in home, or by someone who had a relationship with that person before the injury, an insurer is required to pay no more than 56 hours per week. Okay. This is what we've referred to and what you'll hear as the 56-hour family attendant care limitation. A couple things to say about this though. It applies to family members, but it does not apply to anybody who is not on this list that you see right in front of us. 3 people on this list. It's a relative, someone living in a home, or someone that you knew before your accident. Okay. If you're not on that list or one of those 3 people, then the limitation for 56 does not apply to you. Doesn't apply to commercial attendant care. Okay. And one of the things that families are going to find themselves dealing with is when they are providing a loved one or a family member above 56 hours of care in a week. And they're going to be limited due to the new law. Well, there's nothing in the new law that says they couldn't go and get a commercial attendant care company to cover the extra hours. Presumably that would be more expensive. Even with the fee schedules, it would be additional things for the insurance company to work through. And it could give some incentive for the insurance company to contract around or give a rider for this. So we'll talk a little bit about that. But just know that the new law allows the insurance company to limit for any family member, anybody living in your house, or somebody that you were friends with or knew before the accident. They can limit those persons' care to 56 hours. Okay, an insurer may contract to pay benefits for attendant care that is more than the statutory hourly limitations. Okay, this is recognized right in the statute. So the insurer, they don't have to, but they certainly could. And they could do it for a number of reasons. But essentially, if you're one of the individuals who is receiving or providing family attendant care, and you are either receiving or providing more than 56 hours, this is a good place to start and to try to work out an arrangement with your no-fault insurer to even have those benefits covered. And I will tell you, I have been seeing individuals and claimants and individuals that I represent, their insurers just reaching out to them and letting them know that they're not going to be providing holding any limitations against them. So while the law reads very bad, I've heard good stories so far that they have not been reducing payment pursuant to the fee schedules and the attendant family provided attendant care limitations just right away on June 2nd. That's not the way it has been working. I certainly expect them to take full advantage of this, the insurers. But before everybody assumes that all their benefits are gone, just know that it doesn't have to be that way. There's a lot of reasons that insurance companies might not do it, and they certainly have the options to either contract for or agree to additional premiums to get those benefits and to still collect those benefits. The rider too, mentioned in another part of the statute, but pretty much the same concept. If you buy a limited amount of coverage, let's say you buy the $250,000 PIP level, and you're catastrophically injured, you can buy a rider that allows you to get attendant care above that $250,000, and essentially will increase the limit of your PIP coverage. They could also contract to increase the rate of pay or not be subject to the fee schedules. It seems to be kind of an open format right now, and the law just simply hasn't been in effect enough for all the insurance carriers to actually take advantage of these or to really be using them to the fullest extent. In fact, what I've seen is that for the most part, some carriers have said, we're just not even going to utilize these restrictions right now, and we're just going to go ahead and if things change, then they change down the road. So just keep that in mind, and it's going to be a new system, and the courts will obviously give us direction, and the carriers will, but it's certainly something that should be talked about with your agent to see what options you have to work around and contract around some of the harsh limitations regarding attendant care. And just to say, it doesn't require that insurance companies do this. This will be an optional coverage. And so we'll see what different carriers provide and what products different insurance companies offer. But I think it's a discussion worth having at this point, and there'll be a lot more talk about these limitations in the CPAN town hall and their survivors course. Yep. And so here is the fee schedules and a picture depicting the fee schedules and attendant care limitations all being implemented at one time this month. And as you can see, it's two trains headed for each other. No good result here. There's a lot of momentum on both sides. And at some point, these issues are going to come to light, and we're going to need the legislature and the courts to give further direction on how we're going to provide the benefits, keep people's rights established in Michigan to receive the care that they need, And the way the law was written, there's a lot of uncertainties, but there is a war on multiple fronts. And so this is some of the realities of the combat, the issues that are going on due to kind of the harsh wording that's found in the no-fault reforms. So I'm going to talk about a few things that are happening. One, this is the Andrew lawsuit. This is a lawsuit filed by our firm representing several individuals, and we have co-counsel. And really, this is George Sinus and the Sinus brothers, and Lauren from our firm worked diligently on this, but it's a full firm commitment. We are essentially trying to repeal the certain provisions of the no-fault laws, including reforms to the fee caps, the family care limitations, and most importantly, the retroactivity, the issue that they are trying to apply this new law to claimants who have been in the system and bought a policy 10, 20, 30 years ago and had vested rights under that policy when they got injured. And they contracted for a lifetime of care and a lifetime of benefits without these caps. Those are some of the constitutional issues that are being raised in this lawsuit. Unfortunately, it was dismissed initially, but it has made its way to the Court of Appeals. And I will tell you, there hasn't been a whole lot of movement on it. We've had tremendous support from provider networks and legal community. We have several amicus briefs filed by CPAN, MB, IPC, the BIA, state reps, Julie Brixey, Andrea Schroeder, and we just have a lot of support. There's a lot of people's lives who rely on this system. And so we are certainly taking those issues up to the Court of Appeal on constitutional grounds. And the next movement that we'll know in this case is defense. Their brief on appeal is going to be due for filing Monday, July 26th. After the defense's brief is filed, the court will set the matter likely for oral arguments. And after the oral arguments take place, the court will issue an opinion. I would not be surprised if this issue does eventually make its way up to the Supreme Court, but I think that any decisions, any rulings made at the Court of Appeals level will be looked at by not only providers, but insurers, and will have an impact on how these claims are handled here in the next year or two. Another couple wars on other fronts, wars in the legislatures, not just in the courts. There's a few bills that we have, and we've got specifically Senate Bill 314 and House Bill 4486. These two bills really try to take a stab at fixing some of the fee schedules to a way where the providers could essentially stay in business, that we knew that we could at least rely on rates that we were charging back in January of 2019, that we wouldn't be dropped down to a level where we just couldn't open the doors, that we couldn't stay in business. And so these two legislative fixes, you can see the dates on them: March 24th, 2021, March 10th, 2021. They've been around for quite some time. They've been read in, but they still haven't been taken up by committee as far as I know. Essentially, they're just sitting, and it's unfortunate, but we would like to see these bills ultimately get to the floor and get some talk around them and get them passed. But there hasn't been a whole lot of movement on those, and you might not have heard much about them. There has been a lot of talk about what Senate Bill 28, which was enacted last week. It was signed by Governor Whitmer last week. And it's essentially a Band-Aid patch to the known issues and problems that are happening with this new law. I mean, those legislatures essentially acknowledged that there needs to be a fix, but the fix that they have proposed in Senate Bill 28 simply isn't going to get it done for a number of reasons. For those of you who don't know what it is, it's $25 million appropriated by the state in additional funding for providers of specifically rehabilitative in brain and spinal. But essentially it's for those providers who are going to be hit the hardest by the fee schedules. And it's unique in the sense that it's set up on a first come, first serve basis. And so the first applications that come in and get approved, the money is going to start going out. And once it's gone, essentially it's gone the way I read it. First come, first serve. And there is a lot of uncertainty about the application process, about the forms that'll be generated, about how those will be filled out, what supporting evidence will be needed. Ultimately, this is going to take some time to work out. So this is not an immediate fix, but essentially a provider can receive a distribution from the fund if there's no Medicare code for the fund and the provider can demonstrate that the department fees have caused, under the new fee schedule, has caused the provider to bill at rates that are below the cost of providing the service. So lost profits aren't enough. It's really, you have to show that the cost of the service is more expensive than what you're getting under the new fee schedule. And, you know, it like I said, it's a limited reform. 25 million is probably nowhere close to the hundreds of millions the system needs to really stay afloat and to have all the providers stay afloat. And so to me, it's just too little and too late. And ultimately, it's going to cause more confusion with the forms and submissions and first come, first serve basis, that I just really don't consider this a fix to the issues. But it's important that people know about it because there is going to be 25 million dispersed eventually, if it's weeks or months from now. And there's going to be some requirements on the provider to go ahead and show that they are entitled to relief under this fund. Which reminds me of another point that I guess I wanted to cover for all those providers. This will certainly be covered by CPAN in our survivors course, but the utilization review process is a new part of the No Fault Act. And it has to deal with when bills are denied, what is the recourse for providers to get their bills paid? And essentially, without getting into the real nuts and bolts of it, it's going to be incumbent on medical providers to understand not only the utilization review process, but understand that it's going to be their burden to essentially mount the appeal if the bills are disputed, if they ultimately want to get paid for their services. And Katie Tucker from our firm, she's a partner at our firm. She has really championed the utilization review process from every angle. And so I am not going to get into it too much, but I encourage any provider who is charging for their services and have no fault patients to really understand the utilization review process. There's materials on our firm, and ultimately could reach out to Katie Tucker or see her speak on this issue in the upcoming seminars. So that's just one other thing that I really want to mention, because it's very complicated in the just like with this a sense for this bill that provides relief for providers, it requires the providers to produce a lot of documentation to meet deadlines and to stay on track with things. And it's really something that everyone should understand, because it's just going to be a new part of the no fault system and it's going to apply to everyone. So just make sure that everybody is aware of that procedure and that practice, and that they can find more resources from our firm down the road if need be. And final couple things that I want to touch on today are going to be regarding choosing our policy, and then I'll answer some questions, and stick around for any additional questions in addition to ones that haven't been raised in the chat. But there's a couple things that I really want to stress here when it comes to picking out your policies and what types of coverages you really want going forward from an individual basis. Purchase unlimited PIP coverage. We've talked a lot about that. The amount of services you can require, the amount that you can have to pay for out-of-pocket expenses or services just altogether under the fee schedules, just really could leave you in a very tough spot with limited recourse if you were injured and you didn't have unlimited PIP for a variety of reasons, depending on which policies you pick. But the bottom line is to make sure you can get the care you need and to not go in debt or to have the financial resources you need to get the care you receive. That's why we pick unlimited. So that's always going to be our recommendation. We also recommend that everybody choose uncoordinated PIP. Okay, I know they offer discounts and probably will continue to offer discounts even on tiered levels of PIP options, but uncoordinated PIP is just so much better. It avoids confusion. It avoids having to resubmit 2 sets of bills, first to one and then to another in a timely basis where deadlines apply and bills can slip through the cracks. There's other situations where your health insurance company might have a lien on your tort case. So if you're injured and you want to use the liability hand to get pain and suffering, non-economic damages, really money that should be your own specific tort property to compensate you just for pain and suffering, the health insurance could come in and pretty much take that from you and make you pay for your own medical expenses out of pocket. And so that's another situation that can arise, and another reason that we don't coordinate our PIP. PIP managed care option, talked about the language in the statute that allows them to adjudicate and pretty much control your care. And I think that's just a really dangerous proposition anytime you have the insurance company with their hand that far into the cookie jar. So I would not recommend the managed care option. Bodily injury and umbrella coverage, the fact that we can all be held responsible and liable for someone else's medical expenses on a catastrophic injury case, those damages could be very large. And so something that we never had to worry about before, but now we do. So we certainly recommend having enough liability coverage and checking to see if you can even get umbrella coverage for your liability, because we could all be liable for medical expenses now if we're cause an accident in Michigan. Unfortunately, we don't, but in the event we do, we want to be protected. Uninsured and underinsured motorist coverages. I think these are some of the best coverages you can absolutely buy. They're cheap and well, comparative to what you get, but essentially these protect you in the event that the driver that hits you is uninsured or has not enough liability insurance coverage to cover your pain and suffering damages. In this situation, your own insurance company would step into the shoes of the driver or other driver and essentially provide additional coverage for them, and it would go right to your tort damages, your non-economic damages, and therefore you can be made whole. In practice, this coverage gets applied all the time and it's utilized quite a bit. I think it's one of the best coverages you can buy in Michigan when it comes to auto. And so I certainly encourage, I know the firm encourages everybody to buy UM and UIM in a significant amount. Finally, the last thing that I want to encourage people to look out for are step down policies. A lot of, and you might not even know this is in your policy, but we see them in policies, especially UIM and UM policies, but essentially says that your bodily injury liability, let's say you bought the 250-500, if you hit anybody else, then that's your coverage amount. However, if it's one of your own family members that's injured, that coverage drops down to the state minimum. And it's really I think a disingenuous way to write your own family out of your policy. I mean, your family is going to be with you quite often in the vehicle, driving, and certainly they should be entitled to be made whole if another family member makes a mistake. And the insurance companies use this provision to essentially block your liability coverage from reaching your own family members. And it's just something to be aware of, because I think it catches people off guard when they realize that they don't have coverage to compensate their loved ones or family members if they accidentally run a red light and someone's injured. And so I really want to stress that it's something to definitely talk to your agent about, and just make sure that you don't have one of these step down provisions for family members in your insurance policy. Okay, and so that does it right now for my slides, but I am going to take this time because it looks like we've had quite a few questions.